May it please your lordship. In my individual capacity and as an advocate general, lordship, I have filed 2 contempt cases. So there is some urgency, lordship. So may I pray for listing of these cases tomorrow, lordship? We are in the process of filing. In half an hour time it will be filed. 2 contempt cases under the provisions of 15(1)(a) read with 2C. Deeply obliged, lordship.
But that's why only you are not in.
No, I am not in. I'm little bit confused whether I should wear or not, because this is not a case in person. As an advocate general, I'm filing it, but I have to check up the law also, lordship, on this, whether I should be in uniform or not in uniform.
So there is no problem in that. Uniform was the problem in that. You are not representing yourself. You are
Yeah, I'm not representing.
State.
I have
As an advocate
I
in
have
the
just discussed with the senior counsel, Mr. Mishra also on this. I have little confused, lordship, that's why. But from tomorrow I'll be on uniform, lordship. Deeply obliged.
Adjournment request, if any, from item number 1 to 6. From item number 7 to 13. Adjournment request. From item number 14 to 19.
May I please, Lordship? Lordship, I beg to mention item number 18, Lordship.
Adjourn.
Much obliged, Lordship. That please, Your Lordship. I beg to mention item number 12 here, Your Lordship.
12.
My Lord.
Item number 12.
इसकी नहीं है
After vacation.
कारण तो विड्रॉ किया तो उन्होंने बोला
Mr. Boyan argued so many times.
My Lord, my humble request, though, after vacation, just after vacation, I shall heard.
But it was argued so many times.
No, my Lord, earlier I was not in the case. Subsequently, I was involved.
So,
That is why, my Lord.
in fact, in para 20, Ranjit Singhal just given
Just after vacation, you
not
Lordship.
less than 10 reasons
Let-
not to interfere.
No, I shall move the case on after vacation, just after vacation.
So, okay,
Must apply.
after vacation, the koi date hai. Yes.
Any other request? Daily list for orders, item 1.
On 10/2/2025, we have issued certain instructions. What are your instructions?
In the AMMC rules, my lord, Assam minor mineral concession rules, 2013, there's rule 56, my lord, breach of terms and conditions, consequences.
Rule,
Yes, lord.
Rule 56.
56.
duties of real estate.
Take action against that contractor, since your report itself says that he was indulged in illegal excavation of the mineral.
Since, my lord, the the allocation was granted by the BTC, my lord, Borderland Territorial Council. Therefore, my lord, it was incumbent on them to take these actions, my lord. The
Who was
forfeiture.
the authority maybe, who is for the BTC? Who was the authority?
The authority and the BTC additional PCCF take action, Lordship.
Yeah,
Additional PCCF can take action in BTC, Lordship.
additional,
PCCF. Additional Chief Conservator of Forest. Additional Chief Conservator of Forest.
who is the authority? Sure. Here. This PL petition was filed on behalf of the petition. In relation to a settlement for sand and gravel mining in favor of the respondent number 5. The settlement order was issued in favor of the respondent number 5, granting a mining contract under Dhansiri Forest Division, Udalgiri, allowing to excavate the mineral concession in respect of the mining lease area, Rauta S/G Mahal. It is argued, it is contended in the writ petition that as per the conditions of the mining lease, the respondent number 5 was allowed to excavate the minerals for a period of 5 years from the date of letter of intent issued from the date of settlement. They are not letter of intent, settlement. And he was allowed to excavate up to a certain depth and was also restrained from extraction of minerals outside the mining lease area. Full stop. During the course of the hearing, the scope of the PIL was extended and the state government was directed to frame comprehensive guidelines to check the illegal mining in the state of Assam. In response to it, it was stated on behalf of the Standing Council for the Forest Department of the state on 10/2/2025 that comprehensive guidelines have already been framed and they were already in place. It is also submitted by the Council for the Forest Department that for the purpose of restraining the illegal mining in Assam, the government of Assam has already drafted new minor mineral rules titled as Assam Minor Mineral Concession Rules 2024, and the same will be implemented soon. This court has took notice of an inspection report prepared by the additional Principal Chief Conservator of Forest in bracket Administration and Vigilance in the office of the Principal Chief Conservator of Forest and Heads of Forest Force, Assam, wherein it is mentioned that allegations leveled against the respondent number 5 are found to be true, and he has violated the conditions of the mining lease. Taking note of the fact, this court has granted, has raised a pertinent query to the Council for the Forest Department that what action has been taken against the contractor. Though the contract period is already over. Full stop. Then it Council for the Forest Department takes some time to apprise this court whether there is any provision for taking action against the respondent number 5 who has flouted the conditions of the lease and has illegally extracted the minor minerals out of the scope of the contract. Today, learned counsel, the so-and-so appearing for state forest department has submitted that as per rule 56 of the Assam Minor Mineral Concession Rules 2013, action can be taken against a contractor who has violated the conditions of the lease. As noticed earlier, the contract period is already over. However, as per rule 56(2) in 56 in bracket 2 and in bracket Roman 4, a individual, firm or companies can be debarred for a period of 5 years for grant of fresh mineral concessions in the state in case there is any breach of terms and conditions of the lease, of the mining lease. Full stop. Learned Counsel for the Forest Department has submitted that it is upon the BTC or BTR? This Bodoland Territorial Council to take action against the respondent number 5 since it is proved that the terms and conditions of the mining lease has been violated by him. Full stop. Learned counsel appearing for the respondent BTC has assured this court that the BTC will take action in accordance with law against the respondent number 5 in view of the fact that that a case of breach of terms and conditions of the mining lease is made out in the inspection report. Taking into consideration the overall facts and circumstances of the case, we are of the view that no further order is required to be passed in this petition. However, we hope that the state government shall implement the guidelines framed by it as pointed out by the learned counsel for the Forest Department before this court on 13/5/2024 and 10/2/2025 in full letter and spirit to check the menace of illegal mining in the state of Assam. Stop. We also hope that the Assam Minor Mineral Concession Rules 2024 be soon implemented in the state of Assam. Full stop. The BTC is expected to take action against the respondent number 5 in accordance with law within a period of 6 weeks from today. Full stop. With these observations, this BIL is closed.
Item number 2.
What happened to that appeal?
Appeal, my lord, hearing has already been concluded, my lord.
When the order is
So we want to, my lord, withdraw this appeal.
then it comes to the petitioner has submitted that since the hearing in the appeal preferred by the respondent number, by the non-applicant number,
ID, my lord, respondent number
1, non-applicant number 1 before the, who is the authority?
now, my lord, Director of Land Revenue, my lord.
And before the.
Earlier-
Director of Land
earlier,
Revenue
Lord,
has already been
Commissioner lawyer.
concluded. He does not want to press this IA, hence this IA is disposed of. Resultantly, the rate appeal number 313506/2024 filing number is also be treated as disposed of. Director of Land Record. Director of, before the Director of Land.
Item number 3.
May I please, lordship? There is 2 days delay for filing the appeal, lordship.
What is the merit?
Lordship,
What's the merit in this petition?
lordship, I have filed some,
What's wrong with the learned single judge order? He simply said that since disputed questions are there,
Yes.
therefore approach the
yes,
civil court. Whether the land is outside your patta or not, these are the really disputed questions of fact. They are really disputed questions of fact. Well, condone the delay, but what is the on merit?
lordship, this Said that land is a Pakta land, Lordship, but
No doubt. Your case was that this electric pole is erected
yes,
in the
Lordship.
land of the, in your land.
Yes, Lordship.
They have disputed it
Yes,
and
Lordship.
they have said, you
They
know,
said that-
it's not, it's outside your
Pakta
patta land. Now the learned single judge says these are the disputed question of fact which can
This
only
is-
be decided by the civil
Civil
court by
court.
taking evidence. What's wrong in that? The matter comes upon for consideration of the IA number so and so with the prayer to condone the delay of 2 days in filing the connected writ appeal. Stop. The application is not seriously opposed by the counsel for all the respondents. For all the respondents. Hence, the IA is allowed the delay of so and so days is condoned. Stop. With the consent of the party, IA is condoned, the registry is directed to register the connected date appeal immediately. Then इसका number जो भी note हो जाएगा. With the consent of the parties, the matter is heard. Finally, the appellant has approached the writ court with a prayer. The writ court with the grievance that the APDCL is erecting poles, erecting electric poles on the land falling under the on the land of the petitioner for which they are in possession of a patta. Full stop. The APDCL has contested the claim of the appellants before the writ court and has argued that the electric poles have been installed pursuant to a scheme in the year 2016 and the same has made erected out of the patta land of the petitioner of the appellants. The learned single judge, taking into consideration the facts and circumstances of the case, has observed that in view of the opposite stance taken by the parties, it appears that there are some disputed question of facts which requires evidence to be recorded. Hence, it is, hence, the appellants are required to approach the appropriate civil court for redressal of their grievances. Stop. Learned counsel appearing for the appellant has failed to persuade us to take a different view because admittedly certain disputed questions arose in this matter and the same can only be decided on the basis of the evidence. Hence, we don't find any faults in the this data. The same is therefore.
I'll leave letters.
Item number 4.
May I please, your lordship? My lord, Mr. NJ Khatoniar is out of station, my lord.
Yeah,
Mr. NJ Khatoniar is out of station, my lord. The matter may be taken up some other day.
why?
Mr. NJ Khatoniar is out of station, my lord.
Who is out of station?
Mr. NJ Khatoniar, my lord.
Mr. Majumdar,
No, my lord, NJ Khatoniar.
when he is coming back?
Tomorrow, my lord.
Huh?
Tomorrow, my lord.
Tomorrow, day after tomorrow, and prepare on the matter on the merits also.
Yes, yes, my lord.
Okay, be prepared on merits. The learned single judge has already passed the order under the peculiar facts and circumstances. They are making it clear it would not be a precedent, can't be treated as a precedent. Then what? Why to interfere with this order? The Chokidar was working since 2 decades, and simply because some procedure which was to be followed by the respondent authorities, if they have not followed, what is the fault of him? Day after tomorrow.
Deeply obliged.
Okay.
Item 5.
I
Five
filed
and seven.
5 and 7 minor.
five and seven, my lord, similar order part, and some of the, we have file against common order, 8 numbers of appeal file, my lord, and this court also directed, after condemning the delay, directed the registry to register.
Delay unknown, what is on merit?
Yes, my lord.
What is on merit? Delay unknown. Come, merit.
My lord, in those cases, my lord, similar cases,
Will
it is
list all these cases, what is on merit? All these cases, which has already been admitted,
my lord, the government, central government categorizes employees on the basis of pay level, grade pay.
fine.
And they admitted that they have,
When the government has erroneously granted them the relief, which was the relevant date?
yes,
Which was the relevant date?
my lord, in,
When this fixation was done, what was the relevant date?
my lord, 38, 2000, with effect from 1 and 6. My lord, in compliance
So,
of,
around 2 decades earlier.
yeah, my lord. My lord, my lord, in compliance of central government uh, uh, recommendation committee, we have paid the excess amount,
Yes,
upgraded.
excess amount
Yeah.
without,
The
there was no
erroneous-
misrepresentation and fraud on the part of the employees.
Yes, I'm told.
Then how can you recover?
Well, they have given uh, given an undertaking at the time of,
Whatever may be undertaking or not undertaking,
my lord,
you can't recover that.
as per the Honorable Supreme Court order that
Which
in
honorable-
pass,
Which order, which order?
pass in the case of in the case of the High Court of Punjab and Haryana and
RG Masih,
yeah,
yes.
and
AG Masih or what?
EG
Rafiq
Masih,
Masih.
this order has been passed in the light of Rafiq Masih case.
Okay,
My lord, the Supreme Court in its judgment, in the judgment of the High Court of Punjab and Haryana, uh, it says that the employee is bound by the undertaking.
okay. And recently, the Supreme Court on 4th of April itself, they have passed an order, you can't recover that. Judgment then I. Just 4th of April.
They are group B, my lord. Committee on merit, my lord.
Yeah, that's why only merits, come, argue it on merits. The 4th of
My
April,
lord, any other day.
which other day? Today is
Any
the
other-
best day. Which other day?
Any other day,
You
my
also
lord.
get rid of these
That
files,
will also
old files,
convenient.
and
My lord, I have
ask
to
for
go.
new files.
I have to go this.
Okay, go through it. And which are the cases where we have already condoned the delay?
Yes, sir, your lordship.
Give the numbers of those cases.
Almost all cases have
All-
been get
Huh?
the 6 cases have.
Give the details. We are going to list all those cases along with this.
Judicial notice.
Number दीजिए number number
WN 50 of 2025. WA,
How many writ appeals are there?
yes.
eight.
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 And these two appeals today,
Yes.
5 and 7.
Yes.
Yes, 5 and 7.
You are going to list it day after tomorrow?
Yes.
Get yourself prepared. लिखे 5 और 7 में. List on Wednesday. Wednesday along with. Give the details along with so and so. And be prepared. ये judgment उनको photocopy करा के देते हैं. Judgment. Give them a photocopy and 3-4 photocopy निकाल के रखो या पे स्टाइल में रखो.
Item 6.
For the petitioner, Mr. Sharma. Just pick up. Mr. S. Datta. Okay. Yeah. देखिए, in view of the order dated 2/4/2025, passed in IA number 837/2025 in writ appeal number 67/2025. No further order is required to be passed in this IA. In this IA, therefore the IA number 1018/2025 is disposed of. Okay.
Item 8.
Yes, you are appealing for, and
I'm appearing for Animal Husbandry and Veterinary Department, Lordship.
Uh,
Respondent number 1, 3, 5, and 6.
1, 3, 5, and 6.
Six.
And this 1, 3, 5, 6, and 8. Who is appearing for the state?
I am appearing for 2, 4, and 7.
8 is the private. Nobody is appearing for 8?
No.
Private.
Issue notice. Ms. So and so is appearing on behalf of the respondent number 1 to 7 ka inka presence, whatever the presence. Let notices be issued to the respondent number 8 only, returnable. 8 weeks.
Obliged.
Deeply obliged.
Item number 9 for admission.
Lord, your lordship has decided in some of the cases I got a judgment. It was again the order of the learned single judge that was moved before division bench. In those cases, once I have read the judgment, the consideration which was before this honorable court and the point which was argued before the court was that about regularization of the services of those the appellants who were the petitioner. I was the counsel there before the other single judge. So I was aware of those cases. And ultimately, there was two points which were raised. One point is for regularization of the services, which was negated by the learned single judge. Said, no, we can't regularize your service because you have to see the judgments of Uma Devi. Uma Devi judgment was 10 years of continuous service. So learned singles has said that the divorce of the rules also. Secondly, 10 years service you have not completed. So one-time measure cannot be given. This is one aspect of the matter. Another, sir, Ranesh Singhal just said that there was a judgment passed by a coordinate bench, 2089, which I remember. Those judgments, they said that how can you overread the judgment passed by the learned single judge? Because that said that
The learned single judge also taken into consideration the orders passed by the division bench.
division bench, yes. Now, this judgment, your lordship has passed. I have seen that whether they move the apex court, there was SLP is being filed now before the apex court and a notice has been issued. Notice has been there, but there is no stay. Notice returnable within 4 weeks, the court has said.
May
Now the
also-
question,
may also
what
put
is,
the-
no, what is our case? That's why I'm saying, what is the case before your lordship? There were about 7 to 8 writ petitioner in this case before the learned single judge. Some of the writ petitioners might not belong to GIST. GIST is Jorhat Institute of Science and Technology. Initially, that was a science college. Subsequently, it was amalgamated and there were the engineering colleges in those. But the appellant before your lordship doesn't belong to GIST because we combine. But now this the petitioner, the appellant, that was never considered by the learned single judge to the extent, A, that whether did not challenge the advertisement. There was no occasion because those cases which were before this court and which was moved before the learned single judge, but the learned single judge, you challenged one hand the advertisement and you participated. You cannot appropriate and reappropriate. Again, you are coming for regulation of service. That was one of the contention and
One
decided.
of the contention,
One of the contention.
the whole.
No, that is why I'm saying one of the contention. That you cannot appropriate, reappropriate. We here.
It's 9 years, 8 months without any.
Yes.
Yes.
Whatever point you had taken,
Yes.
the main argument for the learned single judge was that the post of lecturer in chemistry is not fall either in technical or non-technical, and accordingly those judgments will not get. That was your primary argument.
That, but there,
One.
yes.
Two, what is the mode of appointment that has been?
No, that's what I was just coming to it. There was,
The other cases, at least there was.
No, correct.
Supervisory.
no, that's what I was just putting, what was the point that was advanced before the learned single judge? Point A was that it is no doubt those cases where the principal appointees, principal appointment.
Here
But
also principal
no,
appointment.
that's what I'm saying. These cases, those cases were not principal appointed. Those were direct by the department, by the department. So the observation made by the learned single judge, even that maybe a department, these are divorce of the rules. That's what the paragraph was quoted here, divorce of the rule.
Thus, you will have to take your case at least to that level, because here.
No, I'm just-
Is by the principal.
No, I'm saying that principle was on the basis of the letter that has been issued by the government. And on the basis of the letter that has been issued by the government, the principal is appointed.
That letter is only to the extent that the contractual appointment can be made to fill up the gap and the amount would be so. It does not say that you can, this is just a pick and choose appointment.
No. But that's because at that relevant time, there was shortage, there was no particular, there was none.
The appointment
No,
is
my lord will
only
kindly,
for a particular period to fill up that.
no, that I have seen.
Fortunately or fortunately
Correct,
for
that's
you,
I have seen. My lord, the issue,
the selection process got derailed.
but now,
That is now.
no,
Participate.
no, I didn't, there is no, I didn't participate also. I did not challenge the advertisement. I did not, that was a case where the advertisement was put to challenge. Here is a case where I moved before the learned single judge, there is no question of challenging the advertisement, one. I will just place it, but there are 3 points.
Sir, you have known our mind now, what is going on.
Yes.
Better you make those arguments on that. We'll have it if required after the vacation.
Let it be. No, because otherwise she's out of the job. She's out of, because what I would not have trouble.
We want some, because yes, you're right, but what we find that your case is worse than those cases which we have, in which we have, this refused to interfere, sir.
Because,
Then you have to make some extra effort.
no, I will make,
At least first of
no,
all,
no.
you to,
How?
to
No.
bring these persons in level.
No,
in
right.
comparison,
No, lordship is-
those
I
persons whose
also-
appeals
I
have
am-
also been
My
dismissed.
lord, I am also aware of it. When that was moved, I tried to place it before this court, that those cases which are, at least, my lord, it is advertised by the department. Some process.
Some process.
Here, my lord, it is a principle on the, by the government that issue a principle. Now, if it is a principle, what is your right? Because it is, that is your lordship, that is some type
Then
of a better
then
case.
Brother has rightly pointed out, it's a pick and choose and nothing
No,
else.
my lord. Now, that is what I have to, my lord, satisfy your lordship.
You just try on after vacation, any day,
Yeah, I will, definitely. I'll try.
after BU. The request of non-counsel for the petitioner list after BU.
But the only difference in this case, what I found, the difference is that it is not by virtue of any interim order that has been passed by the court. That's a Umadevi judgment. 9 years, 8 months she completed.
Before 10 years. Interim order
Yes.
Before
So-
10 years.
So that's the only benchmark is about 2 months, 3 months.
So that
So
comes
that is,
less.
if your lordship looks into it and says that no, it have to be because there is a judgment of the Supreme Court, 10 years. But that,
We have to go by-
then of course, my lord, it is a issue, situation will be different.
We have to go by that, sir. That
But situation will be,
if we can relax 2 months, why not 2 years?
no.
That is the
There is
question.
a difference. Without the help of the any order passed by the court, my lord.
Let us see.
Yes,
Let us.
I'm deeply obliged.
Item number 10.
May please, Lord. My lord, that's a departmental appeal filed by the Register of Cooperative Societies, Assam. Now, along with the appeal, my lord, there is a IA for stay of the impugned judgment.
Yeah.
My lord, by the impugned judgment dated 13/3, there is an effect of obliterating, my lord, the supervisory power of the register over the
Which is
functioning of the board of
The
directors.
learned single judge has taken into consideration the provisions of the Cooperative Act and come to the conclusion that no such supervisory power particularly in relation to the appointment of a secretary by the
Right.
board of directors, it is a contractual appointment. Here, registrar has no say in
But
this matter.
my respectful submission is, having regard to the scheme of the act,
Yes,
your lordship will find that the supervisory power is all pervasive, my lord, over the function, my lord, over the functioning of the board. Your lordship will now see the effect of, my lord, this judgment. Now, once, my lord, the supervisory power is excluded, then it is amounting
in
to,
relation to appointment of the secretary.
my lord, the appointment.
Otherwise.
Absolutely correct.
92,
I'm coming
section
to that.
92, 110, they're very clear.
I'm coming
powers,
to
I
that,
think,
my lord. Lordship,
Shiva.
kindly, my lord.
That is.
Lordship will kindly grant me 2 minutes time, my lord. I'll try to
No,
satisfy
you
your
have
lordship.
half an hour or a whole
My
day, we are not.
Absolutely correct. Now, so far as, my lord, the appointment and termination is concerned, that has to be preceded, my lord, by a board resolution. Each and every, my lord, action of the board, my lord, requires prior approval in respect of the, my lord, appointment and termination also. It requires the prior
So
approval.
under which section you are saying that this registrar has the powers you show?
I'll come to that, my lord.
section.
I'll come to that, my lord.
Come,
Absolutely correct.
come. Cooperative. First, we'll go through those. provisions.
Absolutely correct, my lord.
Yes.
The appointment, my lord, including termination, has to be done by way of a resolution. Now, if your lordship comes to firstly, my lord, section 3, the purpose,
The power of the registrar.
my lord,
Power of the registrar to examine this, he derived this power from which section of the Cooperative Societies Act?
exactly, my lord.
Yes.
I'll directly come to paragraph 45.
Which 45?
Sorry, my lord, section 45.
Section 45.
45, my lord. Minutes of proceedings of meeting. Every cooperative society shall record in the minutes book in the official language of its station or in English or in any other language prescribed in the bylaws, proceedings of every general meeting, delegate general body meeting, and board meeting.
So what we are asking, you are not answering that, sir.
My
You are
lord,
not
these
answering
resolutions, my lord, are required to be sent to the register for approval.
Sir, you are not answering our. Please. Section 111. Come to section 111.
My lord will kindly see what I
And
am on.
also section 92.
My lord, my respectful submission is, so far as 111, my lord, 49, 49 2L or 92. My lord, apparently the power, my lord, may not be available, my lord, under those sections, my lord. What I'm-
Apparently, if it is not.
what I'm trying to say, my lord,
Derive this power.
My respectful submission is, my lord, if there is a source of power under the scheme, wrong reference, my lord, of a particular provision will not invalidate the action, my lord.
That
This is what I'm trying to submit before
But,
your
sir,
lordship, my lord.
You have not been able to demonstrate that this registrar is having derived power from which provision, sir?
My lord, yes, under section
Your
45,
argument was before the learned single judge 111 and alternatively under section 92 also.
45 has been considered by the learned single judge at paragraph 71, my lord.
Yes.
Now, what the requirement is, the resolution, my lord, of the board is required to send to the register, my lord, for approval. Now, the register may approve or disapprove. Once the register disapproves, my lord, then the resolution becomes subject to, my lord, the approval of the register. Now, termination, my lord, appointment, my lord, has to be preceded by a resolution. My lord, one man cannot, my lord, appoint or terminate. A resolution has to be there, my lord. And that resolution,
Resolution was there. Resolution board's resolution was there.
that is
For
what, my lord,
appointing The
Yeah.
secretary.
no, my lord, the larger question in this particular, my lord, appeal is,
A larger
Whether-
or shorter, there is no question.
No,
of larger or
irrespective of the
shorter.
facts.
Come to the direct
Lo-
provisions.
lordship will kindly see what is the effect of the judgment, irrespective
So
of the
it may-
facts.
Maybe effect of the judgment that amend the
No,
law in
now-
accordance with.
Now, all the
How
boards,
can we?
now all the
effect of
boards, my lord,
judgment?
across Assam, Now they will take
There is
resolution.
no such
They
provision.
will
and
not send
therefore
ballot
if
to the
the-
register.
If the learned single judge interpreted that, then you say, okay, okay, effect of the judgment, then it is to take care by the legislature, not by the courts.
My lord, the power is under the act, under the scheme, my lord.
Which is that, sir?
My lord, section
You
45 is
demonstrate.
there, my lord.
Okay, what the learned single judge has said about section 45.
Section 45, the learned single judge is of the opinion that under section 45, the resolution is not required to be sent to the register. 45 is very clear, my lord.
That's all.
The resolution is
Read-
required to be sent.
Read the relevant part.
Page 85, para 71.
Yes.
Well, page 85, section 45 of the Act has inter alia prescribed that every cooperative society shall record in the minutes book proceedings of every general meeting, delegate general body meeting, and board meeting. The provision of section 45 further requires that the proceedings of all general meetings and special general meetings of every cooperative society shall be sent to the register within 15 days from the date of completion of such meetings. The register shall give his approval of the resolutions within 15 days of receipt of the proceedings. If no approval is received within the aforesaid period, the proceeding shall be deemed to have been approved. Section 45 is, however, silent on the aspect of sending the proceeding of any board meeting of a cooperative society to the registrar for approval.
That's all.
Yes, now, my lord, my respectful submission is, my lord, reading 45 as a whole, my lord, it will appear that, my lord, these findings, my lord, in my respectful submission is misnomer. Because Lordship will kindly come to 45 2B, my lord.
Yeah, read.
In case of a board meeting, by the person who presided the said meeting or by the person who presides the following meeting, wherein the minutes are confirmed. So, my lord, 2B also, my lord, indicates the resolution of the board meeting. Now, my lord, my respectful submission is, if a resolution is immune from the, my lord, supervisory power of the registrar, the effect is some persons of the board will sit, they will take a decision, not only in respect of appointment, my lord, and termination, but in respect of anything which may be detrimental, my lord, to the society and against, my lord, the interest of the shareholders also. Now, if the resolution of the board is excluded from the supervisory power, my lord, it will lead, my lord, to this cascading effect. And throughout the Assam, my lord, there are cooperative banks. There are GPSS, cooperative GPSS, my lord.
Get
There are multi-credit cooperative
Get
societies,
inserted
about
relevant-
thousands of cooperative societies.
the relevant provision inserted in the act itself, not by way of this. In the present set of this provisions of the act, no such power is with the registrar to interfere with the resolution of the board of or decision of the board of revenue for appointment of a secretary and employee.
So far as the, my lord, I'll facing a judgment of, my lord, the honorable, but the bylaw is not with me. So far as the present bylaw is concerned, take
Come
the
with the
judgment.
bylaws, then.
My lord, the bylaws says that prior appointment, prior approval of the register is necessary for, my lord, termination or appointment.
Where you have argued this matter.
No, lordship will
before the
kindly see
learned-
what I'm trying to say.
Where you have argued before the learned
Yes.
single judge.
There is, my lord, the para 71 itself.
70
seven-
bylaws, what you are saying.
Yes, my lord.
Yes.
In the para 71, the honorable single judge has held. Your lordship will kindly come to same para, my lord. The bylaw is mentioned. I'm continuing with para 71, from which I have read, my lord.
Read.
Section 45 is, however, silent on the respect of sending the proceedings of any board meeting of a cooperative society to the registrar for approval. if as per the statutory prescription approval is required, the order which is required to be approved by statutory authority like the register does not become effective unless the approval is accorded. It is not specifically laid down in the act that the board of a registered cooperative society, after passing an order of removal of its chief executive secretary, would need the approval of the register to make the order of removal effective. In the case in hand, had the order of removal of the respondent for dated so-and-so passed by the board of so-and-so required prior approval of the register to make the order of removal effective, the order of removal would have been vulnerable in the absence of approval of the register, and the validity and legality of the impugned order dated 10/1/22 would have been different. But such is not the case here. With the power to remove the chief executive secretary of a cooperative society vested by the Act of 2007, act only in the board of such society without any rider, it is not open for any other authority like the register outside the society to enforce any bylaw on the ground of its non-compliance with the power to appoint and also to remove its chief executive secretary statutorily vested in the board of so-and-so, and the board having taken a decision to remove the respondent for from the post of chief executive secretary. Any bylaw not in conformity of the provisions of 2007 Act cannot stand in the way in terminating the contextual appointment of the respondent for, and non-compliance of any bylaw would not invalidate the power of removal exercised by the validly constituted board of so-and-so in a meeting having the requisite quorum. Now, my lord, my respectful submission is
What's wrong?
the bylaw, my lord, this particular provision, it contains everywhere regarding prior approval of the register. That particular provision, my lord, was not under challenge.
That's why only learned single judge, there is no such requirement of this condition in the Act of 2007, the bylaws.
No,
cannot
my lord, my
override
respect, lordship will kindly appreciate, my
That
lord,
is
my
what-
submission.
Para
What
number
I am trying,
70, para number 70.
my lord,
of
there
the
is no
judgment.
determination at all because there was
This
no
is the
hearing, my lord.
determination, sir.
My lord, the honorable single judge, my lord, has come to a conclusion without any deliberation of that. Unless, my lord, the
Para
bylaw is challenged, my lord,
para-
lordship will kindly appreciate,
para
lordship may reject my my lord, appeal, my lord.
Certainly, if we have power, we have power to reject also.
Yes,
But
yes.
we are granting you the opportunity, and if you feel that we need not to raise any query, then argue it out.
No, no, no.
Argue it out.
I'm sorry.
Okay, then argue.
I'm sorry.
No, argue.
I'm sorry.
Okay, we'll not raise any query. Argue.
No, no, I'm sorry. Sorry.
No, no, what is this way of arguing?
Sorry, my lord. I'm sorry.
We are hearing you, and if we are asking something
Well.
to understand the controversy, you are saying you may dismiss it. Yes, we can dismiss it.
I'm sorry.
And even by saying this only, that you said you dismiss it and we are dismissing it.
No, no. No, that is not, my lord, my.
Is your
My lord, I may have a wrong, say, my lord, wrong words, my lord, that ought not have been. I'm sorry. my lord. My lord, in para 10 of that judgment of the learned single judge, my lord, it makes it
It's after
clear.
2 weeks.
My lord, on the stay application, my lord,
Nothing doing, 2 weeks.
Item 11.
Yes, sir.
The appeal is lost. This appeal is directed against the judgment passed by the learned single judge, dismissing the appeal of the petition of the appellant. In fact, in this lordship, the present appellant, he was working as one of the officer of the Guwahati Municipal Corporation.
When?
And at
When-
that time, lordship, under the provisions of this Assam Town and Country Planning Act, Guwahati Development Authority was constituted, your lordship, in 1962. Section 2D निकाल कर.
Yes,
So Lordship, the Guwahati Development Authority was constituted in the year 1962, Lord. And thereafter, Lordship, when the Guwahati Development Authority decided to construct apartments buildings at Kharguli, Guwahati, Lordship, for allotment to the landless people, Your Honor, and the other needy persons. Accordingly, Lordship, the present appellant, he also filed an application for the allotment of a flat in his favor, Lordship. And thereafter, the flat was allotted. That your Lordship will find at. No? Please for the next application.
36.
Hmm?
36.
46,
36. 36.
36, right. Page 36, annexure 1, Lordship. This is the letter issued by the then chairman of the Guwahati Development Authority to the appellant. iPad में क्यों नहीं होती है? Yes. So Lordship, after allotment of the flat Lordship to the appellant,
building.
Lordship, building, it is a double-story building.
So it's not a flat, it's the whole building.
It is having only ground and first floor.
RCC building, so instead of flat, the whole building without any allotment, you are asked to take possession of that building.
Allotment was given. Allotment was given, Lordship.
Where is that?
And he took the position, chairman.
13/5/1973 order. 13/5/1973, May 1973,
Yeah.
13th of May 1973, page number 36.
Page number 36 is the letter issued by the then chairman of the Guwahati Development Authority. to the- Yes, yes.
Read the.
I am directed to inform you that the matter of your allotment of the housing development colony is under active consideration and will be finalized very shortly. You may take the position of the RCC building, RCC double-storied building, and Sri Dhruva Patwari Mandal will hand over the position accordingly.
So where is the allotment? Sir? Allotment.
But the position was delivered, it was assured, assurance was given by the then chairman that shortly it will be allotted to you.
But-
Suppose,
Thereafter,
Lordship-
whether any such allotment was ever issued, sir?
no, Lordship, please to consider, suppose there is no allotment, but I have been in position since 1973, more than 50 years, Lordship. Then
Then-
what will happen in that case, Lordship?
So under what
The prescriptive
capacity?
right under the
As-
limitation act section
As
20.
being a owner, as being a, this tenant, what is your status?
No, I was an officer of the Guwahati Municipal Corporation, licensing officer.
No,
And
but this, you are under, you are having this, you have occupied these two buildings as a owner, as a allottee, or as a tenant.
as per the page 36, Lordship, the then chairman of the Development Authority assured that the language is that it will be shortly allotted to the appellant.
That's why only, sir, we are asking, where is
but-
the allotment?
Lordship, may be pleased to consider if that extent is taken, Lordship, then I'll be entitled to claim the adverse position. As
File a
because
suit
Lord,
for that, sir. File a
for
suit
that
for
civil
that.
court is there, I know, Lordship, because I have already acquired prescriptive right under section 25 and 27 of the Limitation Act and article 56 of the
For that,
Limitation Act.
Remedy lies somewhere else, sir, not here before this writ court.
No, that
Remedy lies
is a
somewhere
different, no, main issue is not that, Lordship. Here the main issue is this, Lordship. What happened when the Guwahati Municipal Corporation Act 1971 came into force? Lordship, as per section 2D of the GMC Act, Lordship, the Guwahati Development Authority was merged with the Guwahati Municipal Corporation, Lordship. And the Guwahati Municipal Corporation first election was held in the year 1974. So after that, Lordship, your Lordship, please to peruse the section 2D of the GMC Act. The property here, the eviction proceeding has been taken by the GMDA, not by the GMC. This property does not belong to the GMDA, Lordship.
But sir, this, with the merger of the GDA with the GMDA, all the liabilities, properties are required by the GMDA.
No, no,
Then the learned single judge has said, sir.
that is not correct, Lordship. We please to peruse the section 2. Property vested, all employees of the Guwahati Development Authority were taken by the Guwahati Municipal Corporation, Lordship. Because the Guwahati Development Authority Act came into force in 1985, which become effective GMD Act, Lordship, which become effective from 1/4/92 after 8 years. And this Guwahati Municipal Corporation Act is of the year 1974, and it came into, it started functioning, Lordship, from the year 74. And in the Act, Lordship itself provides that the Guwahati Development Authority had merged with the
Guwahati Development Authority Act came into force in,
Lordship.
Guwahati Development Authority Act came into force in which year?
Develop 1962.
19?
62.
So which act 64, the 74 you are referring to which act?
That is Guwahati Municipal Corporation Act 1971. Earlier, Lordship, Guwahati was not a corporation. Before 1971, it was a municipal board. It was a municipal board. Before that, it was a town committee only. Lordship, may please to produce the section 2D of the GMC.
Yes.
All property is movable and immovable.
Yes.
Immovable, and all interest of whatsoever nature kind herein vested in any of the aforesaid local authority. Local authority means, Lordship, GD, Guwahati Development Authority. Immediately before such establishment shall, with all rights of whatsoever description, used, enjoyed, or possessed by any such body or authority, vest in the corporation. Vest in the corporation all rate, taxes, fees, rents, and other sums of money due to any of the aforesaid local authority immediately before such establishment shall be deemed to be due to the corporation. Now your Lordship may come to page section, because the learned single judge has held that GDA was not a local authority. Lordship may see here in section 243. Section 3, subsection 43, local authority has been defined, which says that the development authority will be the local authority. Section 3, within bracket 43, local authority means the municipal corporation Guwahati and also includes municipal board, town committee, panchayat, and development authority.
Your case, is it that your case that with the coming into force of the Municipal Corporation Act 1970, DTA got merged with the Guwahati Municipal Corporation?
Right.
It's actually so. You don't have a case because 13/5/73, how could the chairman, Guwahati Development Agency, issue this allotment?
when
it is not
it
there.
was not there.
Guwahati Development Authority chairman had given the allotment letter
So
in 73, Lordship.
73, so 71 mein this municipal
No,
corporation.
no, this municipal, I already have submitted before your Lordship. Though the act is of the year 1971, Guwahati Municipal Corporation Act is of 1971, but it came into force, Lordship, from 1/4/74, when the first election of the corporation was held. That is not disputed, even my learned friend will admit this fact. Just below section 2, below, Lordship will find the enforcement date of the Guwahati Municipal Corporation. Just beneath section 2 of the GMC Act, Lordship, entry note number 4. Just beneath section 2, heading is repeal of enactment and savings, Lordship. In section 1 of the Act came into force first meeting of the elected councillor after the first general election by notification number so and so dated 11/2/74, published in the Assam Gazette.
Yes,
So main dispute is, Lordship, Guwahati Municipal Corporation is saying that no, the property which belonged to earlier to the Guwahati Development Authority, as per section 2D and as per section 3, subsection 43, Lordship, the property of the Guwahati Development Authority had vested in the municipal corporation and GM is never vested in, because, your Lordship, the Guwahati Metropolitan Development Act came into force in 1985. Enactment was done in 1985, but it came into force with effect from 1/4/92. So when the property of the Guwahati Development Authority has merged,
yes.
so Lordship, Guwahati Metropolitan Development Authority, that act, Lordship, came into force with effect from 1/4/92. So, Lordship, may be pleased to consider very vital point is this, Lordship. When in the year, when the Guwahati Municipal Corporation Act 70 was enacted, the property of the then Guwahati Development Authority merged with the Guwahati Municipal Corporation, Lordship. And at that time, there was no Metropolitan Development Authority Act 1985, which came into force on 1/4/92. So the question of the vesting the movable immovable property to the Guwahati Metropolitan Development Authority does not arise. Apart from that, your Lordship may be pleased to consider
I
that
mean to say that with the enactment of this Guwahati Municipal Corporation Act, GDA was abolished.
GDA,
Yeah,
it has merged with the GMC, Lordship.
so abolished. It was merged with the municipal corporation and abolished, as good as abolished,
Virtually it was dissolved.
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 Then this act of this 1992, which you are saying,
There is no act of 1990.
This, sorry, in 1985, Guwahati Metropolitan Development Authority Act. This 85, this as per you came into force in 1992 only.
149.
Then sir, why this provision 125, sir?
124, 125, 126 provisions, 124, 125 provide that the property vested of the Lordship Guwahati Development Authority
120
now yeah, I am coming,
124, sir.
124,
dissolution of the Guwahati Development Authority.
Lordship, it was
So
already.
it was very much in existence. It never merged with the municipal corporation at any point of time. It merged only with the GMDA when this 85 Act came into force.
That what will happen when the property of the Guwahati Development Authority had vested in the GMC as per section 2D and 243, subsection 43, Lordship, because for last 11 years, there was no Guwahati Development Authority Act, Lordship, please. Now, your Lordship, actually the dispute is, my Lord, between the Guwahati Municipal Corporation and the GMD Authority.
Where is the dispute?
That in that case, Lordship, a duty is casted on the state government to resolve the dispute. Your Lordships are aware, there is a Supreme Court decision that when
Sir,
there is,
even though
intra-department dispute matter should be resolved by the government.
Sir,
Lordship.
sir, we understand, sir. Even though we we accept your whatever argument you are saying, sir. But ultimately, what is your right to remain in possession of the property, sir?
My only grievance is, Lordship, that it is only the Guwahati Municipal Corporation which can issue a eviction notice
Yes,
under
sir.
the provisions of
But,
the
sir,
Assam.
but for that, sir,
Let me-
first of all, you establish what is your right to remain in possession of this property, sir?
My
Under
right
what
is.
capacity?
No. I
Under
may
what
not
capacity?
have any right, Lordship.
Then
Does
if you
it
don't
mean
have
that
any
the
right-
authority will be allowed to follow the, to evict me
Sir,
without
even
following
if
the
you
due
don't have
process of
any
law?
right, you are saying you don't have any right, then whoever the authority may be, if they ask you to vacate the property, first of all, you establish your
So
right.
that should be done by, Lordship, there are many other points also documented. Actually, Lordship, may please to consider the letter written by the mayor of the Guwahati Municipal Corporation to the chief executive officer of the GMDA, Lordship.
What he said.
It was there, GMC has admitted that this quarter was allotted to the appellant.
So where is the allotment order? You just show us. We'll immediately pass. an
Whether I
order.
should prove, Lordship, admitted fact which has been admitted documentary evidence.
So where is the documentary?
Yes, I
evidence?
am coming, Lordship.
Just show us the documentary evidence. You have First of all, establish your right. Then the question will come, which authority is supposed to evict you?
That is true. Lordship, may be pleased to come to. Okay, Lordship, may please come to page 59.
59,
Yes, Lord.
sir.
Lordship, this is my, page 59 is my additional affidavit filed before the Honorable Single Judge. Lordship, may come to page 66. Annexure number 1 of the additional.
Yeah.
This is the letter dated 1/7/74.
Yeah.
Issued by the Guwahati Municipal Order. The following staff of the Guwahati Development Authority who have reported for duty in pursuance of the corporation decision and letter number itna and posted to the branch and pay scale shown against the their names with effect from 1/7/74. The matter for fixation of fee is being taken up separately. So all the implied Lordship, 54 numbers of the implied Lordship, in this annexure, it is 34 Lordship, was of the, who were earlier the implied of the Guwahati Development Authority was taken by the Guwahati Municipal Corporation. And till now, the Guwahati Municipal Corporation, all these officers have retired, but pension is being paid by the Guwahati Municipal Corporation.
Again, we are making it clear, sir. We
There-
are not disputing that you are this, only the authority which can issue eviction notice is the Guwahati Municipal Corporation as per you.
Yes.
assuming that. But at least you show us, sir, what is your right to remain
Yes,
in
yes,
possession of
Lord.
that
I am
property?
coming, I am
On
coming,
what
I-
basis you are
I
in
am
possession
coming,
of the
Lord.
property, sir? You have retired in the year 2009. You are not being employed. The scheme which was floated for the purpose of the government employees has never been implemented. You have taken the possession of the building only on the basis of one letter by a person. Okay, you occupy, your application will consider in due course. You occupy the property. Now you are in occupation. What is your right
No,
to remain in occupation of the
Lordship,
property, sir?
Lordship, I have already submitted that the quarter was, building, double-story building was not given or allotted to me
Huh.
as on rent or anything else, Lord. It
Till
was
date, and
for
the
sale,
another
for
factor
sale,
is,
for
till
sale.
date, you are not, you have
For
not paid
sale.
a single penny. And you are in occupation of the land, government building, without there being any authorization. It's very strange, sir. Be happy, इतने साल रह लिए, अब कृपया खाली करें इसको।
रह लिए वो बात अलग है, लेकिन
आप
eviction
इसको
नहीं
don't
नहीं
continue
उच्छेद
with
करने
this,
की
sir.
उच्छेद करने की शक्ति किसके पास है या पावर किसके पास है? अकॉर्डिंग टू मी व्हाट एवर टिल नाउ आई
Sir,
सबमिटेड,
शक्ति और
तो
power बाद में
वो
आएगा.
गुवाहाटी पोर्ट निगम का है,
First of
वो
all, you
गुवाहाटी
just
पोर्ट
show
निगम
us
का
what
है,
is your right to remain in
गुवाहाटी
possession.
जीएमडीए का नहीं है सर, लॉर्डशिप।
सर ये we admit ये GMD का नहीं है, but sir, what is your right to remain in possession, sir? जिस किसी का भी हो, what is your right?
In that event, Lordship, my humble submission in this, the Guwahati Municipal Corporation may issue a notice. There is a local act, Assam Public Privilege Eviction of Unauthorized Occupants Act 1971. If the notice is issued under Section 4, I will vacate. I will vacate, but GMD high, suppose Lordship, I am a tenant.
So you
Of,
enjoyed for last
of
5
Mr.
decades.
Our AG.
Please, you are enjoying the property for last 5 decades. Now, show some mercy on the government and please
Why
vacate.
I should bear
Please.
Lordship the illegality committed
Or
the
otherwise,
person?
we'll order,
No, no, you
we'll
are-
order that since 1973, calculate the rent. And
Lordship-
you pay the rent and you remain
Lordship,
in
already
possession
I
and
have
regularly
submitted.
you pay
If
the
the-
rent, we'll allow you to remain in the possession.
Eviction proceeding is initiated by the corporation, I will vacate Lordship. Suppose Lordship, Mr. AG and Mr. Saikia, I have taken a house from him on rent.
Yeah.
And if other person comes, I will allow, no, you vacate it. This property belongs to me. Should I vacate?
Then you have to show, yes, Mr. Sekia has given me the property. Why should I vacate? But
Lord-
if you will not be able to show, then certainly
Yes,
people
third
will say
party, Lordship,
vacated.
the Lordship may please to peruse the letter issued by the corporation. Lordship may come to page 75,
75, yes.
Annex 2 of the additional revenue. This is a letter written by the mayor of the Guwahati Municipal Corporation.
Is the mayor's personal property?
Not
Was it the
proposal,
Yes.
mayor becomes the father of the city, Lordship. He has
Father of the
the,
city,
without
father
his
of the city,
information,
but,
without his
the-
information,
the
nothing
mother's
can be done by the
disperse the
commissioner.
property as per his own will. Yes, what is the
Lordship.
letter?
This letter is by mayor to the commissioner GMC.
Yeah,
I have to, I come to know that the GMD has been claiming some of the immovable properties of the erstwhile Guwahati Development Authority, which were handed over to the Guwahati Municipal Corporation as per the decision of the corporation in the year 1974. Guwahati Municipal Corporation took over all assets and liabilities together with more than 50 numbers of staff in the year 1974. Therefore, all such properties vested in the Guwahati Municipal Corporation under provisions of Section 2, subsection 2D of the Guwahati Municipal Corporation Act 1971, the Assam Act 1956, Town and Country Planning Act 1959, and Panchayat Act 1959 seized power due to the enforcement of the Guwahati Municipal Corporation Act 71. A copy of the provision of Section 2 of the GMC Act is enclosed here. Therefore, you are requested not to act upon in this matter of transfer or handing over the property of the erstwhile GDA, Guwahati Development Authority, with the without the sanction of the corporation. So this is the letter. Then next page, Lordship. Page 76, Lordship. This is also a letter from the office of the mayor, the additional chief secretary, Lordship. Please find here with a copy of the letter issued by the Commissioner Guwahati Municipal Corporation to the Chief Executive Officer GMD, whereby the former has violated the provisions of the Guwahati Municipal Corporation Act and acted upon against the interest of the corporation. The Commissioner Guwahati Municipal Corporation acted upon without any jurisdiction. He transferred the right of property of the Guwahati Municipal Corporation without the knowledge of the undersigned. Mayor in council and the elected body of the corporation. On the other hand, he violated the provisions of the section 17 of the Guwahati Municipal Corporation Act 71 by not sending any copy to the undersigned for acknowledgement. For the interest of the corporation, the letter issued by memo number so-and-so is suspended with immediate effect, and refer the matter to the corporation for further decision and decisions thereof. The decision of the corporation shall final. I have written a letter to the commissioner in this regard and advise him not to act upon whimsically, but he ignored my advice and acted upon without any authority in violation of the Guwahati Municipal Corporation Act. The Guwahati Municipal Corporation was constituted in pursuance to the provisions of the Guwahati Municipal Corporation Act as soon as the Guwahati Municipal Corporation was constituted with effect from 14/2/74 for the local body like Guwahati Municipal Corporation, Kamakya Town Committee, Guwahati Development Authority, and some of the panchayat functioning within the Guwahati Municipal Corporation area under the previous Assam Municipal Act, Assam Town and Country Planning Act 1959 and Panchayati Raj Act 1959 respectively merged with the Guwahati Municipal Corporation with their assets and liability as per the provisions of Section 2 of the Guwahati Municipal Corporation Act 1971 and vested with the Guwahati Municipal Corporation under the provisions of Section 22D of the Act of 1971 as per the decision of the corporation meeting held in the year 1974. The erstwhile Guwahati Development Authority also merged in the Guwahati Municipal Corporation with 56 numbers of officers and staff together with all assets and liability and enjoyed the service in the Guwahati Municipal Corporation till retirement with all benefits. All such, all assets and liability vested with the corporation since 1974 and such properties under the occupation of the Guwahati Municipal Corporation belonging to the corporation, GMD has forcibly occupied a part of the building under occupation of the Guwahati Municipal Corporation and started construction. It is strongly regulated. Therefore, exercise of the prerogative power under Section 72 of the Guwahati Municipal Corporation Act and being the head of the corporation, I have submitted my views before the government. Then Lordship may come to.
So only he has submitted his views to the government.
Yes.
That is
But
what-
your Lordship, whether
And,
the
prior to that, the commissioner has already declared, Commissioner Guwahati Municipal Corporation has already declared that this land, this whatever the building belongs to GMDA and not of municipal corporation. 11/8,
that commissioner has
2014, next page
Yes,
78.
that commissioner has written a letter to the GMDA, but Lordship,
the
when there is, please,
Not to the GMDA, to one of the occupants.
yes, sir.
Okay, vacate this land, this property doesn't belong
That's
to
a
us.
different thing, Lordship. I am pleading my case. My humble
Your
submission.
case is also same, sir. You have also been instructed to vacate because it's the property of GMDA.
Lordship, if already I have submitted, if the corporation issue notice, I will vacate, Lordship. But GMD is not the authority, Lordship. It has no.
Just
And Lordship,
show us, sir, what is your authority to be remain in possession? Again, the same question. You enjoyed the building for 50 years. अब छोड़ दे, sir.
Lordship, I have enjoyed due to slackness of the government officials. Why your
That's-
Lordships are not
that's why
doing
only-
that?
That's why only.
Due
you
to
enjoyed the
negligence,
property, now it's.
dereliction of their duty. Why they did not
Your one
evict me, eject
generation-
me
Your one generation.
when I
generation
retired
is
in
already-
2009?
Already get the fruits of the property. Now please have some mercy.
Lordship, if the corporation already have submitted, I'll submit, I'll vacate. I'll vacate.
So you are sure that the corporation may not ask you to vacate?
No, they have,
You are sure?
yes.
They'll
No,
not
no,
ask you to vacate?
corporation may issue section 4 notice under the PPA, public permission. Eviction
It
of,
appears that you are confident that the corporation is not going to ask you to vacate the building.
no, Lordship, they will certainly, your Lordship may direct the corporation, Lordship.
Now, why should we direct, sir? After all, it is their property. They'll ask you to vacate. If they don't want, they don't want.
Lordship, may please to come to page 79. Page 79, annexure 5.
Yes.
This is the letter by the mayor to the Lordship, the Chief Executive Officer, GMDA, that is Guwahati Development Authority. Property of Guwahati Development Authority vested with the Guwahati Municipal Corporation under provisions of section 2(2) of the Guwahati Municipal Corporation Act, movable and immovable assets and liability over the Guwahati Municipal Corporation by government letter number this and that. The government has approved that. The state government has approved that the Guwahati Development Authority should merge with the Guwahati Municipal Corporation. Please recall the context of the reference letter above. I reiterated that all the properties immovable and movable is Guwahati Development Authority vested with the Guwahati Municipal Corporation under the decision of the first election body of the corporation. All assets and liability, movable and movables, were handed over by the government, Lordship, by letter number so and so. It is reported that you have dumping building materials for further development of the 2 buildings at Khargoli. You are requested not to carry any construction of the building at Khargoli further. Kindly arrange, dispose both the building at the earliest that the Guwahati Municipal Corporation may arrange proper accommodation to its employees. Then Lordship may come to page 80. This is the letter dated 18/3/88, written by the Commissioner, Lordship. Sorry. So, Lordship, my humble submission is this, Lordship. As per the government approval, the property of the then Guwahati Development Authority merged with the Lordship, the Guwahati Municipal Corporation. All the employees were taken by the Guwahati Municipal Corporation. And after the retirement of the employees, it is the corporation which is paying the pension amount also. So, purpose. Now, I am coming to the provisions contained in the EM.
में कमिश्नर टीएमसी अलॉट किया है
कितना page?
88
Eh?
88
Lordship, please come to page 88, where the
कमिश्नर टीएमसी
page 88,
लास्ट पेज item 1
last page. Last page. Your Lordship had opined that there is no allotment. Now, Lordship, this is the letter dated 18/6/18, issued by the Commissioner himself, Lordship, to the Executive Officer, Guwahati Development Authority, clarification regarding the official quarter of the. With reference to the subject cited, I would like to inform you that the 2 occupants of the residential quarter at Khargoli, namely Sri Dimbeswar Pathak and Sri Vinod Hazarika is the appellant, Lordship, have been residing in the quarter allotted to them as per the order number so and so, as a GDA respectively, office letter attached herewith. It may be stated that Shri Vinod Hazarika has been allotted the quarter by the then chairman, Guwahati Development Authority, and Dimbeswar Pathak has been staying in the quarter as per order of the Commissioner, Guwahati Municipal Corporation. However, it is learned that the occupancy of Vinod Hazarika has been protected by the Honorable High Court interim order the and so. So it is admitted by the Commissioner himself.
Where is that 13/5/73 allotment order?
Lordship, by implied Impliedly, if your lordship think about it, lordship, when I am in occupation, evict me by following the due process of law. When there is a specific law, lordship, Assam Public Privilege Eviction of unauthorized occupants in 1971. That power can be exercised by the GMC lordship, not by the GMDA. Now your lordship may come to the provisions of the GMDA, which provide that all the actions taken, all the immovable property which vested in the GDA lordship, and all the contracts which were entered by the then erstwhile Guwahati Development Authority will be binding upon the Guwahati Metropolitan Development Act, lordship. I will like that. Lordship, may be pleased to come to section 126 of the the municipal corporation. Oh, the repeal and saving of the GMD Act, Lord. Section 126. The relevant sections of the Guwahati Municipal Corporation Act and along with the amendments up to date in consist with the provisions of the Act shall extend repeal with effect from the date on which the Guwahati Metropolitan Development Authority referred in section 4 of the Act constituted. Subsection 2. The relevant section of Assam Town and Country Planning Act and the Assam Municipal Act, Assam Act Issuance, and along with their amendment up to date, and the rules and regulations made there inconsistent with the provisions of this Act cease to operate within the territorial jurisdiction of the Guwahati Development Authority as referred to in section 3 of the Act, with effect from the date on which the Guwahati Municipal Development Authority as referred in section 4 of this Act is constituted. Subsection 3 is important. Notwithstanding any repeal and inoperative of the relevant sections referred to in subsection 1 and subsection 2, anything done or anything purported to be done or any action taken under the provisions of the said acts or rules or regulation made thereunder shall be deemed to have been done or taken under the provisions of this Act, and all such rules and regulations, if not in consistent with the provisions of the Act, continue in force till rules and regulations are made under this Act. This is one aspect of the matter.
Yes,
So, Your Honor, then Your Lordship may be pleased to come to section GMDA 124-25. Lordship, section 125.
yes.
Yes. 125, Lordship, provides consequences of dissolution of the Guwahati Development Authority. With effect from the date of dissolution of the Guwahati Development Authority specified in section 124, all the members, including this is regarding employees, I am skipping it. B is regarding the fund, or C is important. All contracts and liability which are enforced by or against the Guwahati Development Authority shall be enforceable by or against the Guwahati Metropolitan Development Authority. So here also I am saved, Lordship. But whatever actions were taken by the
Which is that contract? Which is that contract?
contract, yes,
Where is that?
it is a contract.
Where is that?
Allotment, whether allotment was formally or it was not as per law, that's a different thing, Lordship. but I am not unauthorized occupant because it will be deemed to be a contract. When the chairman himself has issued a letter and who handed over the position of the building lordship? The chairman himself. Definitely it is a contract. Then lordship. These were my humble submissions.
যদি কইলো কারো কারণ নাই
বুড়া মানুষ কি মানে?
That's all, sir.
Yes, yes.
That's all. Close for orders.
Matter will go to Supreme Court.
Item 13 and 14.
Only one thing as one fact, he was already issued a notice under section 4, and that final order has also been placed. That matter is pending today before it. That fact, very important fact. Under section 4, under the Premises Act also was served on it.
Before this honorable court.
But another court.
Then that commission.
We are running to that case now.
Entirely different matter.
Go fast.
Item 13 and 14.
How much is 14? No? My lord, I am appearing in 14.
Yes, sir.
In item number 14.
Yeah.
And 13. My lord, this is that matter where the picture photograph is taken and uploaded, and the moment it is served, then the owner has no option but to pay because his transfer of RC, renewal of RC. Yeah, keep it.
There is a particular exercise. If there is a liquid in our thing, I think किसी ज्यादा तो क्या ही लेगा. But be careful. हमें पुलिस नहीं. ठीक है, हम कैसे भी फाइल करूँगा.
वो दवा मंगा दो लेकिन वहाँ
ज्यादा सफर से बहुत दिन भी होता है. हम बहुत लाइफ से तो लखा itu tetap dibeli di atas iya yang buat
itu pun bakuai na yun ya aja bisa
itu mati dulu No, 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 no. तब तो 100% minimum में होता है होता हो गया
बात तो हो गया।
हम सोचते हैं कि
This motor vehicle rules.
no, as far as our petitioner's perspective is concerned, by an executive state, you cannot override the rules. That's the only thing we lost. Because this was the last time which was given to them, Milord, they have not filed their affidavit. And when PUC certificates, they are not issued because of pendency of this.
That we have already cleared.
Yes.
That we have already clarified by.
No, Milord,
order.
PUC part, Lordship has not. Lordship has only said regarding registration and license. Pollution under control certificate, that is an aspect which requires to be gone instead. You should have it daily. So called cycle. No, we get at least. अगर कोई रिकॉग्नाइज है तो नहीं किया
Immediately,
तीन नहीं हुआ यहाँ पे हम लोग किसी की तकलीफ नहीं लगी हाँ 15 16 एम जाने को कितना नहीं किया
Yes.
yes no problem. On the last occasion, query from the honorable court was, what if somebody else is driving the vehicle? Careful. The challan is sent to the registered owner. Now, Lordship will kindly see section 167 and 167A for a moment. 167,
Rule.
yes, of the rules, Lordship, which is under challenge here. 167 of the rules provide for the procedure for issuance and payment of the challan. And 167A is the monitoring, that is the electronic monitoring. Now, if I may take your Lordship to 167A for a moment, Lordship. In PIL 52, it is in page 82. Yes. Now, a challan can simply not be sent. It is what has to accompany the challan, because there has to be some evidence of some violation. Now, what are those things? Lordship will come to sub-rule 6. Your Lordship will find it page 87. Yes. All challans issued under Rule 167 in electronic form using auto generation of challan to the electronic monitoring and enforcement system shall be accompanied with the following information. Clear photographic evidence highlighting the offense of and the license plate of the vehicle, measurement of the electronic enforcement device, date, time, and place of offense, notice specifying the provision of the act that has been violated, certificate as per section 4, subsection 4 of section 65 of the Indian Evidence Act, identifies the electronic record and describes the manner in which it is produced, gives such particulars of any device involved in the production of the electronic record as may be appropriate for the purpose of showing that the electronic record was produced by a computer. Now, let us take the example of Lordship of a moving vehicle, over speeding vehicle. Let us take an example of a speeding vehicle. The camera which is installed, it may not capture the driver inside. Precisely that is what your Lordship's query was. It may not capture the driver inside, whereas it can capture the registration and all of the vehicle. Now, under section 197 of the Act, what happens is, if somebody is driving a vehicle without consent of the registered owner, there is a penalty levied. As a corollary, Lordship, anybody, if my vehicle, I'm allowing my son to drive, he has to have an authorization from me. Now, if that cannot be ascertained, under those circumstances, the notice, the challan, is sent to the owner, the registered owner. That is precisely what. Otherwise, if the person who has committed the offense can be identified on the spot, then he can be penalized then and there itself.
Their objection mainly in respect of two provisions. This, which we find some ports, this sub-rule 7 of Rule 167.
Yes. That is our case, Miller. If now. Now, whether.
And another,
Yes.
probably Mr. Mishra, which is raising, that why I be relegated to the person who has imposed this challan or he has prepared the
No,
challan
Lordship.
to prove my innocence before him.
Lordship, I'll
These
just
are the two.
I will just explain that, Lordship. In fact, I have also faced a challan. So I will explain that, Lordship.
Since you are being paid by the government, you can very well pay the challan also.
Now, if the time period for payment of the challan is 90 days. As per the law. If the payment is not made within 90 days, the matter goes to the court.
Matter goes to the court.
That
doesn't. If that I will withdraw my case.
That is not.
Lordship, I have paid in the court.
Yeah.
I have paid in the court.
Sir, in fact, the problem is what we little understanding which when we were examining this.
Yes.
And I would also like to throw some light on this by Mr. Chaudhary and Mr. Mishra also. Sir, this 208 of this MV Act. It says summary disposal of the case by the court.
এখন দিয়া। মোক
It
কিতাপ
talks about summary disposal of the cases by the courts.
Yes.
Now,
Mr. Jai.
the court taking cognizance of any offense
Hmm.
under this act.
Hmm.
Now, these offenses have been specified in section rule 164, sir, of the motor vehicle rules.
Hmm.
So only those cases where is violation of this offenses specified in rule 164, those cases will go to the court. Otherwise, in all other cases, only the police officer or the motor vehicle inspectors, they can issue a challan and
Yes,
they have
yes,
to
and penalize.
for that they penalize.
Yes.
That is what the mechanism here under.
It looks like.
So now what to say as Mr. Mishra in his petition says recovery of fine can only by the court after adjudication of the courts. That is somewhat difficult to accept looking to these provisions because the government, the legislature has already specified which cases are to be go before the court and which cases are to be decided by the authorities or whatever. Another problem for
But
us.
my lord, can I add one thing, my lord? But normally, legislature also prescribes a summary procedure, but that is again by the court. That is also there, my
But
lord.
here not.
Here
no
it
such
is not.
procedure is there. Now the second problem which we are facing for the purpose of interim order, because certainly we'll hear the cases finally. The Supreme Court has already said implement these rules, and if we are going against it, that may also.
No, my lord, as far as,
May also.
of course, my lord, as far as our case is concerned, the limited stay order which we are praying for is, Lordship has already permitted registration. Now, all that is required is, my lord, pollution under control certificate should also be issued. Because on the
This-
strength of an
136, which rule, 186 or 136?
67, 7, my lord.
No, last time when we passed this.
No, Lordship's passed an order permitting only this, my lord, registration. License and registration, Lordship's permitted, but
Because that-
PUC was not permitted.
No, just a minute. That stay order.
Yes. I think on 5/3, no, no, no.
Five,
ইমান তারিখ আসলে order to stay order to তোমার কিমান তারিখ বলবা?
stay order,
Order to. My lord, the order dated
just a-
3/10/24. Thereafter, my lord, idea was, my lord, they will file their affidavit and lordship will consider the other prayer. The last para, taking into consideration the above facts and circumstances, we make it clear that in cases of pending challans or traffic fines, the licensing or registering authorities are supposed to proceed to process application in relation to permits and taxes of motor vehicle, and they cannot refuse to consider the same. Now, my lord, PUC was not considered on that day, my lord. That was left open.
because this circular of the.
Exactly.
Yes.
And there our case is, my lord, when there is a statutory rule, where is the question of any statutory notification coming in the way? Now, 167 sub-rule 7 is very clear. That notification is annexed to the affidavit filed by the state at page number 103. 9th of May 2004. PUC certificate cannot be granted for vehicles with pending traffic fines. Now, rule 167 sub-rule 7 clearly, lifts the bar, my lord, how can by an executive fiat this bar can be reimposed? এই rules তো কোন তারিখে আহিছে? Seven to কেতিয়া আহিল ন? 7 না? কিমান? 25 নাই। আগতে SOP নাছিলে কিন্তু rules আহি গ'ল। September 2020 না? সেইটো stay কৰাব লাগিব। The lordship that kindly come to page 71 of the writ petition, my lord. There is an SOP of 17 December 2018. Thereafter, this amendment came. Eight, no? One to go side. Oh, one, take it. 110.
110/2020.
আগতে আছিলে SOP আছিলে চোৱা কাৰণ সেই গভৰ্ণমেণ্ট অফ ইণ্ডিয়াৰ নটিফিকেশ্যনখন যেতিয়া এইখন অফিচ হ'ল আছে 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 that was of 18
No. Yeah, on.
exactly no initially SOP में दोनों था तब था वही हम दिखाना चाहते
খবৰ লৈছো ট্ৰেফিক অফিচতো গৈছো নাই কথা
সেইটো বেলেগ কথা, কিন্তু ফৌজতো আছে।
ক'ত আহি জানা? মোৰ 1.5 বছৰ হ'ল। 8,000 টকা লাগিল।
মোৰো 8,000।
পলিউশ্যন লেপছ।
মোৰো বুজিছোঁ ইয়াত। আৰু পলিউশ্যন লেপছৰ কাৰণে ফাইন 5,000। ডিটেইন কৰিব পাৰিবি।
এতিয়া 10,000 কৰিলে পলিউশ্যন ফাইন। লেপছ থাকে। ৰিচেণ্টলি নটিফাই কৰিছে। চব বঢ়াইছে। চেঞ্জ কৰিব।
মোক
2,000 টকা ঠিক।
এই এটা ইমান সময় দিব নোৱাৰো দেই, মই এটা কেছ এটা উঠি আহিছো। কিন্তু দিয়া মই যাওঁ। কৈ দিবা কেছ এটা চলি আছে। যে যিহেতুকে কয় এক্সিকিউটিভ অৰ্ডাৰ দি তুমি প্ৰভাইড কৰা, গতিকে আমাৰ পিএইচডি পাৰ্মিট কৰি দিব লাগে। বাকীখিনি নিশ্চয় দিব পাই আমাৰ যায় পাই।
একো নিদিয়ে। কৰি ল'ব।
Litmus. Yes. One 160 photo come like. Yes. I want to be educated. Then obvious. What can be discussed with? And I have to plead with it on the allegation.
I didn't put back the.
Huh?
मैं जाके बोली, I will
take
take
it.
it.
No, court के सामने कहीं नहीं बैठे. But I'm telling for you, this is what you're saying. Because, see, you will be there, tomorrow you will be this side. You never forget that. No. Do not say no, or maybe go ahead. It's surprise. I think I have to learn.
Chaudhary,
Oh, sure.
this of the last occasion, some government was relying on this clarification or something. This
Is that-
implementation of PUCC software version 2.0 NIC, 9th May 2024, some letter is there.
In fact, that was not from my end, Lordship.
No, the state government has relied upon this letter.
You say, cannot be granted to be. Oh,
There, some mention of rule 115 of Central Motor Vehicle as X GSR issued a notification for amendment in the rule 115 of Central Motor Vehicle Act. What is this notification?
Hmm.
6/6/2018. What is this notification?
It will take time.
Have it,
Yes, Lordship, this,
So this is the
yes, yes.
115.
Oh,
Also one of the business.
anyway, Mr. Mishra.
My lord, your
this,
lordship, one
requires some
observation.
Deliberation before
Yes.
passing and stay order, sir, it's because
Yes,
the.
yes,
Supreme
no,
Court
I'll
order is
clarify,
also there.
I'll clarify in 2 seconds, because what I heard, my lord, if I heard it correctly. My lord, Chief Justice said that first refer to 208, section 208 of subsection 1, which makes an exception. And if the government of India, central government wants, they will make by rule provide for this. And if the government provides, there is no requirement of court. Whereas this is
certain-
what,
For certain offenses.
my lord,
What, yeah.
yes, my lord, my submission is that whether by the act and the rules, the requirement of court in order to determine whether the person pleads guilty or not, because it will be in the shape of mere allegation. He has to plead guilty or he has not to plead guilty. Who will decide? The police? In any case, if your lordship will see subsection 2082, it's court which will decide. Subsection 2, where offense dealt with in accordance with subsection 1 is an offense specified by the central government by the rules. For the purpose of this subsection, the court shall, if the accused pleads guilty. My lord,
What our or my understanding is
my lord,
that since this rule 208 says is summary disposal of the cases by the court in relation to these offenses.
yes,
And thereafter in rule 164, they have specified the
Yes.
offenses, that these
so
offenses
then we'll have to go to the magistrate.
to the magistrate.
Yes,
But in rest of the cases, these provision regarding that the court shall decide whatever the dispute.
it,
Yes,
my
no.
lord, suppose,
Sir.
subsection 2, my lord, that's seen there.
Yeah, that is, a
If I don't plead guilty, because it says the court,
yes,
if
where
the
the,
accused pleads guilty,
where the
Yes.
offense dealt with in accordance with subsection 1.
yes,
Subsection 1, again they say once
no, offense dealt with, my lord, these are offenses which requires investigation.
but sir, if the legislature has deliberately identified that these are the cases which requires adjudication or something else, and rest of the offenses, suppose this parking zone, no parking zone, and many other things.
Yes.
That these they said there is no requirement for
Well, it-
adjudication by the court, and this person will
To-
issue a challan with some electronic evidence that
Yes.
this is what.
208 only requires of summary disposal, but there are certain cases which cannot be disposed of summarily. Therefore, that case will have to be tried. And my and it's only if they plead guilty. What we do? Bulldozer. Bulldozer. It's not possible. Where I'll plead guilty.
Certificate, what's like, that will be linked with the wire.
Yes, sir.
My lord, 208 starts with court taking cognizance. So when a case comes before the court, when challan is filed before the court and court is taking cognizance, other than the cases which are reflected in 164, then they will try it summarily if it pleads guilty. But otherwise, every challan has to be filed before the court.
So 6
Every
months,
challan,
suppose
my lord.
in case
Yes,
the police doesn't take any action, challan is prepared, nobody is paying the fine.
yes,
And if they don't take any action
yes,
in relation to that, even though they have not produced it in the court or not
Yes.
submitted in the court,
yes.
then after 6 months, they can't do that.
No, but they are doing it. I have my case.
After 6 months, they
Yes,
can't do that.
yes, fines have been realized. I will show. I have annexed. They cannot do it because 468 CRPC,
No.
they'll be
this,
bound to cognizance.
The Motor Vehicle Act itself
Yes,
bars.
yes, there is a bar.
Motor Vehicle Act itself bars it.
But they are doing it because they are not renewing our PUC certificate and others. Everything is stopped. No, CRPC. My lord, it's in CRPC. The bar is in CRPC. I've seen 468.
468 specifically says that
Yes.
after 6 months,
No,
nothing
no.
happens. They can't take.
No, they can't take.
any
And another thing, they cannot realize because under 241, if your lordship will have 241, section 241 of CRPC, who can realize the fine? 241. No, I'm sorry. It can be. I'll just give my lord.
Here?
No, not 241, my lord, I'm sorry. I'll just give my lord. Who can realize the fine? But the fine can only be realized by the magistrate and no one else. CRPC, isn't it? Into section.
Yes, sir. Yes, Mr. In matter requires some deliberation, sir. So we'll admit these petitions and list it for final hearing. Say after some time. we'll list it for final hearing.
As per our interim prayer lordship, that executive order that cannot overrule the statutory law. So lordship, we are we pray for our
We'll
interim
examine.
prayer lordship. So 167 subsection
Having
7.
heard the learned counsel for the party. For some.
Discovery.
Clear of the view that matter requires the hence I think however, looking to the fact that the petitioner has raised a grievance regarding withholding of fitness certificates as well as
Pollution under control.
fitness certificates in the absence of pollution under control certificate and that the respondent authorities are harassing the registered owners without there being any fault on their part. We deem it appropriate to list this matter list these matters for hearing in the month of June 2025.
Your lordship may give a date. Can you give a date?
June mandate.
First week of June. lordship.
23rd of June, sir.
Well,
23rd.
at 421 CRPC, if your lordship say I got mixed up, that is by the court only. Realization.
Realization by the courts.
My lord.
421.
421, my lord.
Warrant for levy of fine.
Warrants for levy of fine. When an offender has been sentenced to pay the fine, the court passing the sentence may take action for recovery of the fine in either or both following ways. Then there are procedures.
Yeah, procedure.
They cannot recover. Illegally, they can do anything, and which they are doing.
No, by pressurizing you. That will
That's
not
what they are
rescue
doing.
you
Yes.
and,
Yes.
that is not the, this recognized
Yes.
method for the
Yes.
purpose of recovery of
My lord, in bulldozer case, there is a word that
on the last occasion, in
Yes,
para number
that's the
71.
basic requirement of rule of law. The court cannot be dispensed with, my lord. Your lordship has constituted e-courts. And your lordship, Mr. Chief Justice, you said that the Supreme Court says follow it. Supreme Court didn't say you violate. Supreme Court said follow the procedure and then submit the challan to the court.
Oh, that's right. But somewhat, what we are facing the difficulty because on one hand, the Supreme Court is saying implement it and it
No,
is supposed
implement
to-
is, my lord, they
In
can
accordance
implement
with
it,
law,
they can
obviously.
send the challan to the court. Nobody has any objection. First day, if my lord Chief Justice,
Not-
you'll
they
remember,
consider it's a-
your lordship, we were sitting with Justice Suman Sam, and it so happened he was present when this was inaugurated. He
Yes.
said so. So, but my lord, the rule of law cannot be changed by anybody.
Can't be, can't.
Lordship, as regards
23rd of June.
Lordship, as regards interim prayer, my humble prayer is that Lordship kindly prepone the date, Lordship, because people are suffering, Lordship,
Will consider. 23rd.
for no reasons.
Item 15.
May I please, my lord? My lord, here the order passed by the Central Administrative Tribunal is under challenge, my lord. The impugned order is at, my lord, page 21, my lord.
Yes,
My lord, the impugned order starts from page 21.
yes.
My lord, here the learned Central Administrative Tribunal has interfered with the order of penalty. My lord, pursuant to a disciplinary proceeding, the respondent was, my lord, given a penalty of reduction of pay in the same time scale by 2 stages for 6 months without cumulative effect. So this was the punishment given, my lord, and the order of punishment was dated 25 to 2014.
Yes.
My lord, after that, my lord, the employee has preferred an appeal.
Yes.
And since the, my lord, employee is a Group A employee, the appeal as per the rules has to be decided by the president, my lord. And accordingly, he preferred an appeal on 10/4/2014. So, my lord, since he has preferred an appeal, the consultation from the UPSC before after deciding the appeal was necessary. And accordingly, my lord, the UPSC has, my lord, void order dated, my lord, 35, sorry, my lord, 8/5/2018 at page 145. UPSC decided the matter, my lord, and held that the punishment imposed is, my lord, adequate. And subsequently, my lord, The appeal preferred by the respondent was also decided at page 153, my lord, by the order dated 30/5/2018. Now, my lord, the grounds on which the learned Central Administrative Tribunal has interfered with the order of penalty is twofold, my lord. The first ground is, my lord, the ground of delay in the conduct of the proceedings, entire proceedings, my lord. However, my lord, while deciding the matter, my lord, there is no discussion on the merits of the case, my lord. It's a simple, my lord, observation that since there is a delay, the order is bad in law. And second, my lord, is at page 32, my lord, which I was referring to. My lord, the tribunal has held that the UPSC's advice should have been furnished to the applicant before the appellate authority decides the matter. Now, this requirement, my lord, is not as per the rules. The rules, my lord, does not require furnishing of the copy, my lord. And the reliance placed on the two Supreme Court judgments, my lord, these judgments, my lord, now I have been informed that, my lord, the issue is before the larger bench. Well, there are two conflicting decisions by the coordinate benches of the Honorable Supreme Court, my lord, in this, my lord,
Dhani Prasad.
RP Singh matter and TV Patel. My lord, Union of India versus RP Singh and Union of India versus TV Patel. My lord, there are two coordinate bench decisions by the my lord, the Honorable Supreme Court. In one, it was held that, my lord, the supply of the copy is necessary. In the other hand, my lord, in the other judgment, in the TV Patel's case, my lord, the Honorable Supreme Court has relied on two constitution bench judgment and held that no, the supply of the UPSC's advice is not mandatory in view of, my lord, provisions of Article 311, my lord, which was brought by way of an 42nd amendment, my lord. So Article 311, if I may point out, my lord. It is a case of a major penalty, my lord. Major penalty was imposed. So under the, my lord, Railway Servant Discipline Appeal Rules 1968, my lord, initially, when the proceedings were going on, my lord, there is no requirement of consultation with the UPSC. It is only at the appellate stage, my lord, the consultation is mandated as per the rules and was accordingly done, my lord.
This earlier order of the Tribunal 19/5/2016,
Yes.
in OA number 169/2016.
That was to, my lord, dispose of the appeal.
That order is there?
Yes, my lord. Page 229, my lord. After that order, my lord, MA was filed, my lord, praying for extension of time to dispose of the appeal. That was also there, my lord. The subsequent orders are on next page. page 231,
Later on, after passing of this order.
this order, my lord. We filed an IA that was allowed, my lord, and the extension of time was granted till 29/5/2018, my lord.
Mr. Counsel, you are appealing for the private.
Yes.
In this OA, which was prepared in the year 2016, what was your prayer?
My lord, to set aside the penalty order as well as, my lord, I was not given the promotion at that relevant point of time.
In 2016,
2016, my lord, I was retired from service.
this 169/2016 OA, you have preferred before the tribunal.
169 of 2016, yes.
That is page 228, the order is page 228.
Yes.
So what was the prayer in that OA?
Actually, my lord, today I don't have that copy of the original
Because
application.
it appears that
Yes.
in
Prayer-
that way,
prayer
you
is not-
only pray, give a direction to them to
Decide the
dispose of
appeal.
this appeal.
Yes.
You have not raised any ground that these disciplinary proceedings are vitiated on account of delay and everything. You have not taken that ground.
No.
Now, once you have not taken that ground, now it was open for you to, while passing of the appellate, challenging the appellate order, you can take all these grounds.
For 2 years, he did not challenge the order. The initial order of imposition of penalty was 25/2/14. And when he preferred the first OA, my lord, he had already retired from service. He retired on 30/4/2016.
We'll hear this matter. We'll hear this matter. Let me pass it to the petition. The tribunal has grossly erred in allowing the OA preferred on behalf of the respondent while impugned order dated 15th day of March 2024. Mainly on the ground that there was delay in initiation and completion of the disciplinary proceedings against the respondent. It is contended that after passing of the punishment order against the respondent, it was not open for him to take this plea. It is further submitted that the tribunal has set aside and quashed the penalty order as well as the appellate order on the ground that the UPSC advice was not furnished to the appellant, to the respondent before the passing of the appellate, before passing of the order by the appellate court. Learned counsel has submitted that under the prevailing rules, there is no requirement of furnishing UPSC advice at the appellate stage to the delinquent. Full stop. Learned counsel appearing for the respondent has supported the impugned judgment passed by the CAT. Having heard the learned counsel of the party at some length, we are of the view that matter requires consideration, hence admit no need to issue notice as parties at the sole respondent is represented through through advocate. Full stop. During the pendency of this writ petition, the impugned order dated 15th of March 2024 passed by the Central Administrative Tribunal Guwahati bench in OA number 378/2018 shall remain stayed.
Item 16 and 17.
In 16, Lordship, Malad, the affidavit is ready. If I may be granted a few days' time. 17, of course, Malad, the SP Kachar has filed his affidavit.
Item number
17, the SP
Yeah.
Kachar has filed his affidavit. Malab, in 16 also an affidavit will be necessary. If I may be granted a few days' time, Malab, the affidavit is ready for swearing.
Particular and counsel appearing for the state in PIL number 2/25, takes some time to file counter affidavit. Wait for is granted. Please
Deeply
consider.
obliged.
Just after.
One.
week.
All right.
Right.
Item 19.
Lordship, what has happened is that Mr. S. Bothakur was here, Lordship, but suddenly he had to go to court number 17. And-
As per order dated 3/6/2024, your lordship, the petitioner counsel is supposed to file a reply to the affidavit dated 28th of May 2024.
Yes.
That has not been filed yet, your lordship.
What happened?
On 3/6/2024, you sought some time to. Okay. This court, on 3/6/2024, this court is granted time to the counsel for the petitioner to file response to the affidavit filed on behalf of the state as well as the BTR. However, till date, that response has not been filed. And it, counsel for the petitioner is granted 6 weeks further time to file the response. List up to 6 weeks.
Item 20.
Section 14 Surface Act, my lord, mandates, my lord, the district magistrate to do the needful for recovery of the possession of the mortgage property within the town mart program. But my lord, it is seen that, my lord, this is not happening, my lord. The order which has been granted to in our favor 28/10/2024.
This returnable 2 weeks.
My lord, for private responsibility, lordship, can we take Dasti service, my lord?
All this through registered AD and Dasti.